Yes.
Item number 1.
Yes, Mr. Bora, what is this?
My Lord, there has been a delay of 17 days in filing the appeal. Prayer for condonation of that delay.
Yes. What's the matter about?
Actually, what happened, my juniors had collected the order from the registry, which was not actually signed by the issuing authority first. After preparing that, and when I came to know, I had to apply again after 1 month to get it signed by the authority.
Okay, come to the merits of the matter. What's it about?
My Lord,
17 days, I don't think you'll have objection.
No, Your Lordship.
Yes.
17 days.
Yes.
the writ petition, my Lord, was,
What's the matter about?
it's about unemployment allowance under the NREGA Act. The job card holders, there are 103 job card holders who had not got unemployment and allowance.
What it was dismissed, now you came before the single bench for the allowance.
Yes, my Lord.
And what happened for the single bench?
Now, the petition was rejected on 5 grounds, mainly.
What was
I have
the
come
ground?
against those grounds only. The grounds were I have given it under paragraph 10, my Lord. Number 1, that the job card holders who are to be benefited from the outcome of this matter has not been named.
Not been named.
Actually, they have been
Then?
named. The list have been is there. List is there.
The
they have
very,
been
the
named.
very persons seeking relief for, they're not, the
This
no
is
and
a
the
ground
picture,
taken
they're all
by
unknown.
the learned court below. I mean, the single bench. To this ground also. When the list is also given, list of entire job card holders have been
Are
given.
you also, your allowances have been paid also?
I am also one.
Yeah, your money has been paid.
Yes, in the list also, my name is there in the list also.
So you're coming for personal grievance or you're coming
Along
as
with
a-
all. Initially, I had come under Order 1, Rule 8, mistakenly. But at that time, the learned single bench had asked me, is the problem for all the 103, are they all in similar status? And I said, yes. And thereafter, it proceeded and the court issued the notice.
Who are you actually? Are you the
At the
chairman
time
of the VEC?
when I filed the writ petition, I was the secretary of the VEC of the village. As the secretary, I filed for the others also, as well as
So you
for
say
me.
that the money is not paid by the BDO to them?
Yes. Thereafter, when my tenure had gone, another person had come as secretary. Then the question came whether I'll be allowed to proceed with the case for all others. So I got the authority from the others also and filed it in the court. At that time also, there was no objection that the fees for all the petitioners will have to be paid. So it went ultimately to the hearing, final hearing, and there it was pointed out by the learned single bench that the court fees for all have to be paid. Only for one has been paid. So court fees for 102 have not been paid. So that is the main point. On this,
The court fee is not being paid.
yes, my lord. On this, I had actually made a verbal submission that even now we are ready to pay because we had not paid because there was no order or nothing said.
It's not a question of order, it's a technicality which has to be met. Simple.
Initially, it was accepted by all parties, by the court also.
Where is the writ petition in the lectures? Page?
Page 53, madam.
Your original writ petition.
And the cause title where I have written is on page 57. It's a writ petition filed by the petitioner in the same interest as all of the job card holders of Chirakata VC under provision of Order 1, Rule 8.
Oh. So at that point of time you came, was any authorization given to you when you filed the writ petition?
At that time, I had come as the secretary of the VC.
Where have you said that in your writ petition?
Then thereafter, when my secretaryship had gone, after the new election, this question had arisen. Then I was asked to show the authority, and I had duly shown the authority. But the question of payment of fees had not come up. till the last date. And that date I had verbally made a submission that I'm ready to pay the fees. But I think somehow, because of some, from single bench to division bench, the learned judge was moving, so there was...
Carry the appeal, I think, will be futile. If you have anything, these other people will have fresh cause action if they have been paid, if the amount is due to them. But to carry the appeal on the basis of these pleadings...
I'm ready to pay the fees. All the people are ready to... At that time, we didn't know that we had to pay. As the proceedings went.
Why the prayer yourself says here that to pay unemployment to so-and-so, to each job card holder,
Yes, ma'am.
104 of them are there. So...
See, if I'm allowed to pay the fees, I'm ready to pay even now.
Anything to say?
That's what I want to pay, actually. I want to pay the fees and get the judgment. That's...
It's too late in the day, Your Lordship, to rectify
And you
that
can't put
defect.
initial ground in the appellate stage.
I was not given an opportunity, my lord. That's my...
No, there is no question of opportunity because
I had made a submission during the hearing that I'm ready to pay.
If there are more than one...
Earlier also, nobody had... It had gone for 5 years, the case, since 2018. This point was never raised by the opposite parties.
Because the matter was never heard.
Not by the learned court.
Never heard finally. That is why.
Initially, the Lavazima functions were not done properly.
I don't want to argue with the council, but that means by your argument that suppose interim order is granted initially when a case is put forward.
Yes, ma'am.
Right. Then at final hearing, that case is dismissed, interim order is vacated. Will you mean to say that at that time interim order had been passed, how can my case be dismissed? That logic can't be. That's the same thing here. At the time when the matter was in process, fine, well and good. But then when the matter is finally argued, then the technicalities have to be met. So on this ground, I don't think we can entertain any appeal.
The thing is that till the last date, this point was never raised by any party.
Doesn't matter. Let's see the
order also, one order I have annexed, which says the respondents have no objection.
Is at page 336.
No objection doesn't mean that they can say that, okay, fine.
It happened to be, we presume that it is accepted.
At page 336, Your Lordship.
36, okay. If the Government Council no objection on paying first appeal court fees, you'll say, okay, it's fine. Page?
Page 336, Your Lordship. Judgment dated 13 September 2023.
336. Oh, short judgment.
Very short. It is on a technical ground.
Yeah. Grounds are given here.
Anything else to say?
Last
Your Lordship, in the writ petition, Your Lordship, he was the only applicant.
Yes.
There were the names of the other job card holders were never mentioned, the details were not given, and he had claimed that he was the secretary of the Village Employment Council, so he filed this
Which
writ
I was
petition.
actually at that time.
Anyway, in the meantime, Your Lordship, when this was pointed out that the other job card holders' details were not there, then by an order of 26th
October, I think.
the job card holders' names were included, but the court fees were never paid for any of the job card holders, Your Lordship. And then in the meantime, Your Lordship, he had also ceased to become the secretary of the Village Employment Council, so his authority, his locus had gone. But now, at this stage, Your Lordship, he has brought an authority in the appeal saying that he is authorized by all those job card holders and he's included the names and he now wants to rectify the defect. But be that as it may, Your Lordship, so the judgment, the writ petition was dismissed by the single bench. Now, Your Lordship, he has claimed that he has not got compensation and that they never got any job as per the scheme. But we have filed an affidavit, Your Lordship, before the single bench stating that jobs were given to them and for two work orders had been issued in their name in the year 2016, one in January. They completed the work and payment was made to them. So the issue of compensation or payment of any allowance doesn't rise. Second time, Your Lordship, there is a dispute among themselves. There are two parties. They could not resolve the dispute and they never completed the work, although the work order had been issued, Your Lordship. So the question of making any payment to them when no work was done by them and does not arise. So, Your Lordship, both on technical and on merit, Your Lordship, this appeal has no merits.
As many as 9 affidavits have been filed, my lord, by both the parties. And during that, a chart had been made
Take
that
down.
during the 5...
You can't. Sorry, Mr. Bora, you can't carry this. But in this case, WA 51/2023. Yeah. First one, in this case, this is an application for condemnation of delay of 17 days
17 days.
in preferring the instant appeal. Stop. Heard that our counsel and peruse the grounds set out in the said application. Stop. Also heard the learned Additional Advocate General has no objections to the condemnation. Accordingly, the delay of 17 days is condoned and the appeal is taken up for consideration. Stop. Registry to registry to register and diarize the appeal. This case accordingly disposed of. On the main case, the instant writ appeal has been preferred against an order dated 13/9/2023 passed by the single judge, wherein the appeals where the petition was dismissed on the grounds which have been with the dismiss. Next paragraph. Mr. P. Bora, the counsel which submits that the dismissal of the writ application was purely on a technical ground, which he has sought to correct here at the appellate stage, and has also offered to tender the required court fees, inasmuch as the main ground for dismissal was that the writ petitioner had preferred the writ petition on behalf of 104 job card holders without the requisite court fee being paid or their names being enumerated. Stop. Next paragraph. He therefore prays that some consideration be given, and the writ petitioner, who was the erstwhile secretary of what is this? Of the Village Employment Council of Chirakata Village, Mawson Ram West Khasi Hills, be allowed to remedy the lapses as pointed out, as reflected in the impugn order, and that the writ appeal be taken up for consideration. Stop. Next paragraph. MS T. Yangi with so and so for the state respondents has at the outset submitted that fresh and additional grounds cannot be taken up, cannot be advanced by the appellant, inasmuch as the lapses were never corrected during the duration of the writ proceedings. It has been further submitted that apart from the technicalities which have not been fulfilled, stop on merit also, the instant matter does not deserve any consideration, inasmuch as whatever pending dues of the job card holders as per instructions, and which she has also filed by affidavit, have since been cleared, and whatever amounts outstanding may be due to internal disputes between the persons themselves. He therefore submits that there being no merit in the instant appeal, the same should be dismissed. Stop. Next paragraph. We have earlier counsel of the parties and peruse the materials, as also the impugn order which is before us. Stop. The findings of the single judge, which is not disputed even at this stage, is that the appellant is no longer the secretary of the Village Employment Council, and as such, his representation of the aggrieved job card holders also stands in doubt. Stop. It has also been recorded in impugn order that there is no authorization by any of the village employment council members authorizing the writ petition to file the petition on their behalf, and that neither does the writ petition disclose or the affidavits filed therein disclose the names and details of any job card holders. Stop. It has been further held that the requisite court fee in such matters also, when an individually is allowed to file jointly on behalf of several writ petitioners, has also not been paid. Stop. Next paragraph. In the face of these circumstances and the materials on the record as they appear, there is no error in the impugned judgment, nor does it call for any interference on the submissions of the learned counsel for the appellant that the defects can be corrected and the matter be reconsidered. Stop. Next paragraph. For the sake of convenience, the relevant portion of the impugn order is reproduced here and below. Take any more? Second page. Yes. Stop. Next, last paragraph. There being no substantial grounds or any merit to interfere in the impugn order, the writ appeal accordingly stands dismissed. However, no orders to cause. That's a secret. We have to break again the bench. Subpoenas doesn't mean this.
Supplementary list, item number 1.
Subpoenas doesn't mean this.
My Lord, we are challenging the 2019 Amendment Act of the Maram Sameship Act 2006. Maram Amendment Act of 2019.
Maram?
Yes, Maram Act. Now, in exercise of, my Lord, Subpara G, Subpara 1 of Para 3 of the 6th schedule, District Council has enacted the Khasial Autonomous District Council election nomination and electors of CMship, Deputy CM of Maharam Sameship 2006. The act was in place. Now, 2015, they sought
2006
to
Act came into being.
It
was assented by the governor. And that
assented
same
by
year
governor. It was
then
enforcing.
what happened?
And 2015, they want to introduce certain amendments and send to the governor. Governor referred it back, sent it back. And after 2019, they published the new bill again. Amendment.
15, they sent an amendment.
They sought for amendment.
That was rejected.
And rejected, sent it back to the council
What happened?
for reconsiderations, and they keep it quiet. And later on, after 3 years, they published another similar amendment in 2019 under Para 11 of the 6th schedule.
The parallel is a
And
publication.
Para 11 for publication. And they sent for assent of the governor. Now, governor has returned it back with certain remarks because we have filed the objection. So objection of the Maram Sameship need to look into, and other aspects are there. So district council ought to be consider this aspect. Now, district council in letter, some exchanges were there, and subsequently they have, my lord, I'll just refer. They immediately, without placing the bill before the house of the district council, they obtain the assent of the governor and they publish it. Now, my grievance is to, my lord, on merits. Secondly,
You can't be agree with the process. You agree with the contents of the act.
my lord,
What does it say?
contents of the act is, my lord, here as per the customary practices, the post of the mantri is a lifelong. Now they reduce him to a headman who enjoy only 3 years. Those are.
I mean, is there a distinction between headman and mantri?
It is not there also given.
No, because headman is a different entity altogether.
My lord,
Mantri is different.
My lord, therefore, that distinction is also not there. There is a confusion prevailing in the act.
Where's the CD
Now,
Act?
may I take your lordship at one? The return back, my lord, may I just come to page number 37. The governor said, page number 37.
Yes.
My lord, the second paragraph, may I read out, my lord. The contents of the letter that is and such, along with the enclosure as forwarded to you, white letter number such, may also kindly take into consideration. Further, the agreement such and such referred to in your letter cited above may kindly be submitted for placing in the bill before the governor of Meghalaya for his assent. Thereafter, my lord, page number 38, another communication was also there to the district council. And
This is February 21.
my lord.
Yeah, then
And
what happened?
39, my lord, district council has given some clarifications. Page number 39.
Yes.
My lord, with reference to the subject cited above, I inform you that due to typing error from the office of the KJTC Legislative Secretary, that the word land regulation appear instead of the word land administration in such and such and such of the proposed amendment bill forwarded by the Executive Committee, such and such and such.
Yeah.
Now, thereafter, my lord, page number 40. Now, from the government, my lord, they have written this letter. Now, may I read, with reference to the letter cited subject above, I am directed to say that the law department of the government of Meghalaya, after careful examination of the bill, has made the following observations. So, 2 observations were made, my lord. You are requested to kindly consider addending the above clauses and resubmit the bill thereafter. Now, my lord, page number 41 is the bill they have published. Now, date of publishing is, my lord, 26 September 2023. And now it says, my lord, the act was passed by the KJTC on 25th July 2019, my lord, received the assent of the governor on 15 September 2023. My lord, published the Gazette of the Sunset on 26 September. Now, governor has returned the bill in 2021-22. Now, they say the act was passed by the House of this Council in 2019. My lord, when we see the, therefore, Rule 93 of the, my lord, Meghalaya and Assam District Council Constitution Act 1951, the act is the rule is very clear. Under Rule 92.
Oh, in this section 2 of this amendment,
My
it says provide rights of Ministry shall also be known as Rambachno headman.
lord, that is on the merits of the case I question, my lord. Para 2, my lord. In principle, like section 2, after clause say the following proviso shall be inserted, namely, provided that the right samsar pay, the Mantri shall also be known as
why you agree with this?
My lord.
If it's been clarified in the Amendment Act that the Mantri shall be known as Rambachno, maybe it's a custom there or something that the Mantri is also the headman Rambachno of the rights house empire.
My lord, there is no distinction between these two, my lord.
And that's very good. That means you don't have any grievance with that.
But we
And
have
then what about the proviso after subsection 3? It says the private rights house empire, where you can see the post Mantri shall be reported. So you mean your grievance is that if anybody has to occupy his office for lifetime,
that is the customary practices.
but they have the power to regulate the custom also.
That is true, but my lord, they cannot destroy my humble objection. My
Why
own
do you
objection
see
in
destroying?
the.
Is it not in furtherance of a more efficient kind of democratic system?
That is true, my lord. But the core object of this bringing act and the bill is to secure and safeguard the customary practices, not in contrary to law. But my lord,
Now, one thing, Mr. Changreso, in this rights house empire, the Mantri also functioned as Rambachno.
as a head of the village, administrative head.
Yes, I mean, you can say Sardar, whatever.
My lord.
But the thing is that so the Mantri is always been the same person only.
Same person.
Then you don't have no grievance with section 2.
No, they will have a grievance.
Then what grievance?
No, grievance is, my lord, Mantri is separate, and the head of the village is the headman is the head of the
dual
village.
purpose doesn't matter. If Mantri he represents before the CM Darbar, and if he discharges his function as a headman also, why? If that is the custom there, then that has been codified.
My lord, that is one dispute, one objection. Second objection is the reduction or demotion of a lifetime chair to the
We can look
3
into
years.
that. I'll look into that.
And another one is the notifications, my lord, without placing the bill. And rule, my lord, rule 93, 92.
Yes, Mr. Kinta, what do you have to say?
I couldn't understand how could they possibly be aggrieved by the fact that there is a tenure for the particular head of a village. In this case, we have treated the head of the area, rights house and pair, as a headman, and there is a tenure. The democratic process is that it's elected by the villagers of that area, and this lifetime issue is a very dangerous thing. A person do whatever he likes, and for lifetime he continues.
No, of course, it's subject. It's not like that. Doesn't mean it's always
So far-
subject to complaints and.
So far this
correction.
matter is concerned, how could the writ petitioner be aggrieved by this? This is a codification of the customs that is prevailing in that area.
Yes, but it doesn't matter. That goes against that. See, the thing is that also, Mr. Changre, so how does it offend or how is it repugnant? How is it ultra virus?
My second limb of submission is, apart from merits, second limb of submission is that, my lord, when the governor refer back the bill is required to place before the House for discussion and
So you're
voting.
attributing some malicious kind of
My
act
lord.
on the part of the
My
council
lord,
in
there was no
in
House
getting
summon.
the act passed.
My lord, there was no House summon. Internally, my lord, they obtained, the executive committee has maneuvered the power of the legislature and got the assent of the governor and
Now you mean
published.
to say that when it was returned back, it should have been placed again before the House
My lord,
for reconsideration?
if I may please that rule, 92 and 93
Yes.
of 1951, it is very clear.
Consistent with council rules.
Well, the Constitution, I've given the list of books.
That's the one point, isn't it?
My Lord, we kindly come to Rule 92 first.
What are you reading? Constitution Council rules.
My Lord, this is the Assam and Meghalaya Autonomous District Constitution of District Council Rules 1951.
51. Yes, there'll be 51.
1951. In that compilation,
Compilation is not here.
compilation it is there.
It is there. Very good.
In compilation.
Where is it?
Page number 7, you start from page number 7.
Okay.
Now may I come to relevant rules. 92, my Lord, page number 39.
Okay.
39, my Lord.
Very good.
May I read, my Lord? Former
Yes.
repeat, okay.
93.
92, my Lord. When a bill has been passed by the District Council, the Secretary shall, if necessary, be renumber the clauses, revise, and complete the marginal notes thereof, and make such a purely formal consequential amendments therein as may be required, and a copy of the bill shall be submitted to the chairman and shall be signed by him. After the bill has been signed by the chairman, the secretary shall send an authenticated copy to each one of the following: to the executive committee for information, to the governor for information through the secretary, District Council Affairs Department, Governor of Meghalaya, if the bill does not require the approval of the governor, being not so specified in any of the provision of the 6th schedule, or to the governor for approval thereof if it is required under any provision in the 6th schedule to the Constitution of India. Now, 2093 is the important matter. When a bill which has been passed is submitted as in Rule 92.2.3 and is returned by the governor with a message to the District Council for reconsideration, the point or points refer for reconsideration, or that the amendments recommended shall be put before the council by the chairman and shall be discussed and voted upon in the same manner as amendment to a bill, and it shall be presented again to the governor for his assent.
Yes.
Well,
Maybe
so
you
it is
should
not
notice-
missing. It's very clear. It's not that.
You have to go to your legal department. Heard Mr. H.M. Senior Counsel assisted by so-and-so for the issue notice. Mr. V.G. Quintana, Special Counsel, present on behalf of the respondents number
327.
327. No further call for. Mr. Q. Varachaji is present on behalf of 1 and 2 as such. No further notice is required. List after 4 weeks for affidavit. That's the only point they have, because there's no question of stay. Presumption of validity is always there.
Item number 2.
I do.
Here that judgment is yet to be delivered by the Calcutta High Court, Lordship.
It's been reserved for judgment.
Yes, reserved for the.
It's quite some time, my lord.
Sometime meaning
It's more than 6 months.
more than 6 months.
Yes.
What do we do then?
But that will have direct bearing on this matter, my lord.
I mean, it is essential. Yes, okay. Since the parties submit that the judgment in the Calcutta matter is still awaited, unless this after
After vacation?
after vacations to await any outcome. Yes.
Possible.
Daily list, item number 1.
Yes, please, Lord.
Doesn't matter at all.
This matter is still pending before 9 judges bench, my lord.
9 judges bench.
Lord,
Yes,
I think
If you
one thing is
you lost an order.
My lords, I think there is a confusion because in
Daily list.
the supplementary list there is item number 3 as well. I think my learned friend is referring to item number 3 of the supplement list.
Oh, Mr. Advocate General, this is a different matter. In PL number 13.
I'm sorry.
It's hearing.
Where's supplementary list hearing?
Limestone Boulder Association matter, my lord.
Oh, what's this limestone boulder? Says.
This is with regard to power of the state government to impose cess on mineral, my lord. My friend has challenged the power of the state virus, and this issue is pending. If your lordship will see, your lordship's order, my
Okay,
lord.
then we'll pass orders later on. We'll take up this item number It's item number?
Item number
Number
one.
of the main list. Right.
I'm sorry.
Yes. I will pass on to the
It's filed in my individual capacity.
Yes. Yes. Last order.
As per the last order dated 19/10/2023, the state as well as NHIDCL was to file independent reports regarding the progress of the work.
Lordship, we are filing it right now.
One page report you took how nearly 2 months to file.
No, Lordship, we have filed the last report even. We are quite diligent in the report.
In terms of audit 1910 independent report, we have the state independent report.
Last report
from your side.
last report
And
we
from the
had
NHIDCL.
NHIDCL has not been filing. State has been filing report.
You file it within 1 week, we'll take it up again. Rather than having scraps of paper hanging around. Yes, counsel for Mr. K. Khan, Leonard AAG. So for
At
responding.
least today's report we are filing. Lordship.
You report, once you file by your 1 page report.
No, normally, Lordship, what has been the practice in this PIL was that we have to give a report. It was not in the form of an affidavit. So just and we keep informing the court.
Dr. Mazika, your report ready also?
I'll file an affidavit.
Lordship, package 1 is very important.
I already got. The thing is that, Mr. Khan, I'm a little bit handicapped with my eyes, and this kind of thing is not.
Absolutely. No, Lordship, we'll file it.
Is it originals there? Originals there.
Lordship, you can see the original copies here.
You give the original copy to your other counsel. That's the kind of regard you have for the court. Huh?
No, absolutely. Apology, Lordship. Apology.
The second copy.
Lordship, can you see package 1? Package 1 was very crucial. That has been stuck up for quite some time.
The civil work where? Package 1 is where?
Package 1, Lordship, starts from
Chalupara point right up till
There's an overbridge, felling of tree. This court has already granted a stay for felling of the trees.
No, Deputy Commissioner East Khasiels has written letter to members.
this
New
is
Shillong
where the-
Township.
My lords, this is with regard in Upper Shillong, the Indian Institute of Geometrical Sciences. There was some objection regarding parting of that land. To that extent, some letter has been written. So again, it is nowhere.
So there was a
Status
slight
report
bottom.
basically indicates, well, some letter has been written without indicating when the letter has been written. What is the status of that letter? Well, it's nothing. Whether they have agreed, there is no clarity.
But is the work going on in this?
Lordship, yes, the package as per the NHIDCL, Lordship.
This is the one that was abandoned.
Lordship, no. Because of this bottleneck, Lordship, there was and this court has also granted.
IAGM is the Indian Institute of
Geometrical Sciences.
That the meteorological.
As per the NHIDCL, Lordship, the alignment has to go through that line only because that was approved. So what basically they are negotiating is if they can be given an alternative arrangement. So discussion was on. We have brought it on the report of the court that they.
And the land's not so huge. It was only 2,449
44, Lordship, yes.
Square meters.
20,000. That's 25,000 square feet.
So keeping this aside, the entire work is in progress. So far, package 1 is concerned, Your Lordship. And package 2, Your Lordship, will kindly see that. Basically, package
This is
2.
which part? Package 2 will be?
Package 2 will
I'll
start
give-
from Shillong
I'll
after.
give the exact breakage as well.
After burning.
After?
Package 2, my lords, is
After
after Milliam.
After million.
Letter of award been issued, collected bidder and so and so. Contract evasion balance. Federal RB has been handed over to the government. Our now construction proposals yet required and since okay, the only toll plaza remains in package 2.
Lordship.
Apart from the agreement which is yet to be signed. Package 3.
Technical feasibility of modified element
stop
of the
bypass.
proposed peninsular bypass has been deliberated and public consultations are conducted. Accordingly, the matter for finalization or alignment has been taken up by competent authority in NHIDCL. So NHIDCL will be the competent
Had that been done?
But I'll request it.
Then seems nothing. Then package 4.
Motion
As it is
by
not possible to change the line, NHIDCL is willing to construct cross drainage culverts to avoid destruction of water bodies to this stage. The villages are yet to agree to the proposal. Deputy Commissioner East Khasiel District is taking up the matter with the headman.
So everything has remained status quo.
Package 4, we have some
in
problem.
practicality, my lords, all the reports will indicate that nothing has really moved, except for on paper maybe.
And Your Lordship, package 5, the technical bit has been floated for the balance work. So technical evaluation by NHIDCL again. So Your Lordship, so far state is concerned except for package 1 and 4, where you have to talk with Deputy Commissioner. All the other packages, Your Lordship, the NHIDCL will be the competent authority to...
Suppose this court prescribes a time limit, do you think that all these things can be resolved?
So far, Your Lordship, Deputy Commissioner is concerned, Your Lordship, their headman part, because there have to be a lot of negotiation.
No, because this order of 1910, I've just seen just now, it's conditional. On the other things being fulfilled, then this order will stand the way of the felling of the number of trees required.
In package 1.
Yes, in package 1 only.
Lordship, only in package 1. Their case was PIL regarding not felling of the trees. And the court extended this PIL to take care of the entire packages 1, 2, 3, 4, 5.
Construction.
We filed an affidavit in the month of March, though it is 9 months old, but that will give a clear picture of the entire package, 5 packages.
Package 1 should not be million. Package 2 is. Package 3 products now, package 4. Package 4 is. What to do? Is this situation, and what will happen? And nothing will ever happen.
Lots of bottlenecks.
Too many bottlenecks. According to the report, that means that since the last date, that was on 19th of October.
Well, nothing has happened.
And now 1st December, you report, I mean, nothing has happened.
But Lordship, we kindly see package 1, at least the allotment of land.
It's just across the table they've talked, nothing else.
So some letters written, my lords, that's neither here nor there.
There is some progress, my lord. Package 1, the work was earlier awarded to a contractor.
Then at least we should get that on record, I mean, here before us.
NHIDCL Lordship, so
I would pray that let NHIDCL also file an affidavit, and then your Lordships will take up the matter. Because that would give some clearer picture, because there's absolute ambiguity.
Status of the Shillong Dowkey Road as on 1st December 2023 on all the 5 packages has been submitted by the General Advocate, Additional Advocate General. A perusal of the same, however, does not disclose as to the extent or advancement of work that has been undertaken since the date of the last order of this court dated 19/10/2023. Like for NHIDCL, represented by Dr. N. Mozika, so has not furnished any report today pursuant to the order date 19/10/2023. However, he prays that he may be allowed to bring a more detailed information by way of affidavit. Next paragraph. In his view, the circumstances, as much as the status provided by the state respondents also sketchy, that the respondents filed an affidavit to give a more detail, especially the state giving a more detailed picture as to the status of the work in all the 5 packages. Just let the matter appear after 2 weeks, and so. You kindly file it. You don't construct winter time, then when summer comes again, then...
Absolutely, then we have the issue of landslide and...
Back to...
It's become a horrifying experience for anybody traveling that side.
Everybody, it's like impossible.
Item number 2.
Lordship, before the hearing commences, Lordship, I have a small prayer, Lordship. In item number 4, Lordship had directed me to file an affidavit in the petition. Lordship, I have filed the affidavit, Lordship, it appears that because it was transferred from Manipur, Lordship, we had not attested the second copy, Lordship, only the first copy, because the second copy we generally certified as true copy, Lordship. May kindly take it on record. I have supplied a copy to opposite party also, Lordship.
You filed it today itself?
Yes, my lord. It appears it filed today.
Well, at first, the other cases may kindly be taken up, my lord, because
We are not adjourned down one.
One second. Have you served copy to the?
Yes.
You have
Mr. Panam is not there, my lord.
I'm not there, Lordship, but before my learned friend starts, Lordship, I'm making a prayer to the court, Lordship, MC 41 of 2023 be taken up first, my lord.
your application for dismissal of the writ.
Right.
Yes,
That the
Because,
matter
Lordship,
becomes
if
factual.
my application succeeds, we are not required to address the Honorable Court, Lordship, on the writ appeal. If Lordship, on the writ appeal. And if my application is rejected, we have to address the court in the writ appeal. Why I'm saying so, Lordship? I'll just take Lordship. Why writ petition is a file? Writ petition is a file challenging some order issued by the competent authority by the petitioner on the ground that his his fundamental right is infringed, and the order issue is contrary to the law. And the Lordship, when the court allowed the writ petition, he got the relief. The order which was existing prior to the impugned order got restored. And the Lordship, the writ petition is dismissed by the learned single judge. In the writ appeal, Lordship, if the appeal is succeeded, Lordship, the order impugned stand costs, and the order existing prior to the impugned order got restored, revived. But in the case where the order impugned is no longer the existing as on today because of some subsequent act of the authority, what is there to decide in the writ appeal matter? That is exactly what is happening in the present case.
No, you mean to say that those subsequent orders,
Yes.
which the petitioner alleges that prima facie contempt has been made out, which actually are frustrating the order of this court.
Lord Sahib, I'm not confusing with the contempt. If my Lord friend, Lord Sahib, if my friend still consider.
Now, your submission was upon that with the passing subsequent orders, the entire dispute before should be washed away. It's entire fresh course of action.
I'll try to satisfy. I'll try to satisfy the court, my Lord. If my submission is accepted, Lordship, then the Lordship, nothing remains to be decided in the writ appeal. And if my submission is not accepted by the court, Lordship, that is still issue to be considered and decided by this court matter. Lordship, may I appreciate in the writ petition filed by my friend, Lordship, 4 orders have been challenged. What are those orders, Lordship? One order 29/9/2021, dissolution of the governing body, and the Lordship, the withdrawal of the granting aid granted to this private aided college, my Lord. And the another order is the Lordship, 27/11/2021. That is the order restoring the granting aid without the portion of the dissolution. And the another order is the Lordship, 29/11/2021. That is the Lordship, constitution of ad hoc caretaker governing body. And the Lordship, another order, 18 December 2021, issued by the Director, Higher and Technical Education, Lordship. It has it also the same order, Lordship, with effect, which was on 29/9/2021. But that order, Lordship, seems to have taken as a rectification measure because they were saying that the government has no power, it is a director. Therefore, Lordship, it is the same order that the dissolution of the governing body, Lordship. These 4 orders were challenged before the learned single judge, Lordship. And the Lordship, for reason given in the judgment, writ petition has been dismissed, Lordship. Against the dismissal order, writ appeal has been filed, Lordship. Their primary contention is, Lordship, that the violation of principle of natural justice, which is also portion of the rule applicable in the rule governing the aided college in the schools in the state of Manipur, Lordship. Lordship, the matter could not be taken up with Imphal bench because of want of appropriate bench. So they filed transfer petition, and the matter got transferred here. That's the reason, Lordship. During the proceeding, Lordship, when my Lord Justice then Chief Justice with my Lord Justice but Judge Lordship, then the Lordship, there wasn't a positive order, but there was an order issued by this Honorable Court giving the opportunity to the state government, Lordship, to take up rectification measure, Lordship, rectification measure.
That means, in sum and substance, they found the order of the single judge unsustainable.
No, I'm coming to the Lordship. Then the Lordship, what I say, the Lordship, there is no positive direction from this court, either to do this or not to do this, but given a liberty to the authority, to take rectification measure, I would say, Lordship. Subsequently, Lordship, what happened? State government have cancelled the order impugned in the writ petition on their own, Lordship. The order challenge is no longer in existence because of the issuance of the order by the state government cancelling the order of dissolution of the earlier governing body, which was issued in March 2021, Lordship. Subsequently, Lordship, Director also issued a corrigendum in the same line. And the other 2 orders regarding the Lordship constitution of the ad hoc, the caretaker governing body, their term having been expired, and on the initiation of the authority in terms of law, a new governing body came into place, Lordship. They are not party here. And the constitution of the new governing body was challenged by the appellant by filing MC 174 of 2022. When, Lordship, we pointed out it is not maintainable, then the Lordship, my friend, appearing for the appellant, have withdrawn that MC, with the effect that, Lordship, new constitutional GB, which was on 6 October 2022, Lordship, still operating. In the meantime, Lordship, what happened? The earlier order issued in March 2021, constituting the GB, which was dissolved by the state government, that was issued at a time when there was a judicial order operating against the authority, Lordship, from taking up. Because the principal in charge, there was dispute. That the principal, Lordship, when his order was interfered by the Honorable Court by judicial order, he was the one who initiated the process of the Lordship, the constitutional governing body, which are represented by my learned friend, Lordship. In such scenario, Lordship, when these 2 orders, which is the primary order challenged in the writ petition, as on today, admittedly, it is not existing. In such situation, what is there to decide by this Honorable Court? And the Lordship, in this regard, Lordship, the Shipping Corporation of India case, Lordship, I will take, Lordship, just for a minute, Lordship. May I take, Lordship, some statement in my writ petition, in my MC case?
Well, let's take MC. Because only one thing is that since your affidavit has been filed just today, there is a contempt. I don't know whether we can take up the contempt today or not. That's the only thing. But that's.
No, Lordship, I leave everything to the Honorable Court.
Yes.
But what I'm trying to say is that, Lordship,
let us see
everything.
This case, yes.
Yes.
It's a bit warm. Yes.
Lordship, page 13, M1.
Yes.
Lordship, that is the order of the Constitution of the GB.
Page 21.
Yes, which is represented by my friend, who are represented by my learned friend, my Lord. Then on 29 September 2021, next phase, Lordship. My learned friend has chosen not to file any objection to this MC case. So, Lordship, by operation of law, whatever I have stated in this misapplication, Lordship, stand uncontroverted. That is a fact. Page 14, my lord, 29 September 2021. Lordship, in excess of power provided by Section 27, Lordship, Lordship, that order dissolution of the governing body at page number 13 was issued, and the withdrawal of the granting act. And the Lordship, in the order, a liberty was granted to the aggrieved person to file a representation to the government for reconsideration within a period of 15 days from the date of receipt of the order. But, and the Lordship, this governing body have not straight away challenged this order of 29 September 2021. They filed a writ petition before the Honorable Court, before the learned single judge of the Honorable Court. Which, it is not a miscast, but that is not disputed. And the Lordship, the order in the writ petition challenging this dissolution order.
29 September order.
Yes. In the writ petition filed by them challenging this order, Lordship, a prayer was made by the learned counsel appearing for the writ petitioner that they will be happy if the writ petition filed before the authority get disposed of. That was the order. It was passed by Justice Jame. And thereafter, Lordship, that writ petition was considered and disposed, and it was rejected. Lordship, thereafter, Lordship, they filed the writ petition, which was the subject matter of this writ appeal, from the writ petition which arises, my lord. And the Lordship, then page number 16, my lord. This is one of the order also. Yes. Page number 17, page number 16, Lordship, is order dated 18 July 2022. It is from the Director of Education to the Principal in charge, Lordship, for initiation of process for constitution of new governing body during the pendency of the case, Lordship. After the writ petition got disposed of, Lordship, on 18 July 2022, before the disposal of the writ petition, Lordship, and the constitution of new governing body, in pursuance thereof, Lordship, by following a rule applicable, new governing body was constituted. Page 17, 6 October 2022, Lordship. And the Lordship, it says that general principle in the condition governing payment of granting act in the state colleges in the state of Manipur.
Yes.
Manipur Education Court, so and so, in the process of the Department of so and so, the governing body of the Northern Birhari College, Khundrakpam, consisting of the following members, is hereby constituted with effect from the term of 3 years, for the term of 3 years. For the principal of Northern Birhari College, Khundrakpam, shall convene a meeting of the new governing body to elect the chairman and the secretary of the governing body from amongst the above member and the provision of Manipur Education Court, 1982, at the earliest, Lordship. This order, Lordship, is how to challenge it by filing MC 174 of 2022 in this batches of writ appeal. And it was
order 6 October 22.
Yes, 6 October 2022.
Yes.
But that MC, Lordship, was withdrawn by the applicant, who are the appellant. Meaning thereby, Lordship, this order is not interfered in any manner by any competent authority, including any court, my lord. And the Lordship, when this writ appeal was taken up, may I take my lord to page number 18, order passed by this court.
Yes.
Prima facie, upon hearing for the appellant this state, it doesn't appear that impugned judgment order can be sustained or could have been any justification for the impugned dissolution notice of September 29, 2021 having been issued. At any rate, the relevant notice of dissolution appeared to be contrary to the provision of the grant in court that it courts. In such scenario, state government is afforded an opportunity to take remedial measure as suggested in which need not be recorded. However, considering the gravity of the matter and the causal illegality in the issuance of the relevant notice, time afforded to the state is till 4th September 2023. The matter will appear on such that no prayer for adjournment will be entertained in any circumstances. In the event the state of Manipur takes corrective or remedial measure, as may be found appropriate, the matter may be allowed to rest if otherwise law will take its own course. Since the matter has been transferred to this court by the Supreme Court, it is made clear that learned lawyer may avail of the virtual mode of appearance. However, any excuse of lack of connectivity, particularly on the part of the state, will be completely disbelieved. As Lordship have seen it, this order doesn't have any positive direction. It is merely a liberty granted to the authority to take remedial measure and the corrective measure, Lordship or rectification.
See, but only one thing was the point of reading this order is that, you see, findings are already been rendered by this court, that the order is unsustainable.
No, Lordship, the finding, Lordship, the observation is there. I'm not saying that observation is not there.
Justification for impute resolution
No,
of
Lordship.
September 29.
Lordship, I would
that
say
means
that
the 29/9/21 resolution has been disapproved.
Lordship, it is Lordship, it is observation, but Lordship, if we look carefully in the entire order as a whole, Lordship, there is no any positive direction. It is merely liberty granted to the authority to take remedial measure, Lordship.
Corrective, see, one thing, Mr. Pono.
Yeah, I'm coming to the Lordship.
Now, in the event the state of Manipur takes corrective or remedial measures as may be found appropriate, the matter may be brought to rest. If otherwise, the law will take its own course.
Lordship.
Now, it's up to the court's appreciation that
no, I'm coming to
whether
that.
those measures are remedial
Lordship,
or not.
now question is, Lordship, whether the state government has taken corrective measure or remedial measure.
Yes.
If
Now, you can
state
satisfy
has
that,
not taken any remedial measure,
that the measures
Lordship,
taken were
if the
corrective.
state has not taken a remedial measure, Lordship, what the Lordship say is right, Lordship. I have nothing to argue, Lordship. But whether we have to find out whether the state has taken a remedial measure.
If it's remedial in nature,
next page,
well
Lordship.
and good.
Next page, page 20. It was issued on 1st September 2023.
Yes.
Made it. Whereas in terms of the government order 29/9/2021, the governing board of the Northern Birhari College Khundrapam was dissolved and concurrently the grant in it provided to said college was withdrawn and suspended with effect from the said date and until further order. And whereas the said government order dated 29/9/2021 has been challenged in the court, and in relation to the same, a copy of the latest court order dated 31st August 2023, passed by the Honorable High Court of Meghalaya in writ April number so and so, in the case title so and so, has been served to this department. And whereas a minute and detailed consideration of the government order dated so and so, the Honorable High Court dated so and so has been done in regard to the opportunity being afforded to the State of Manipur to take remedial measure as suggested by the Honorable High Court of Meghalaya. It is deemed fit and proper to accept this suggestion and cancel the government order dated 29/9/2021 inter alia by reserving and keeping open the legal rights, contention and the remedies as available to the State of Manipur under the Manipur Education Code 1982 and other relevant laws as applicable. This is to enable and empower the State of Manipur to initiate fresh proceedings by keeping the same issue open for further consideration with the leave of the Honorable Court of Meghalaya, as the matter is expected to rest without legal decision on the merit of the case. In view of the suggestion made by the Honorable High Court of Meghalaya by so and so. Now, therefore, the Governor is hereby pleased to cancel the said government order number so and so with immediate effect and convey the approval to the Directorate of University and Higher Education, Government Manipur, to issue an appropriate order in this regard. Further, with regard to a subsequent order issued by the Government of Manipur and the Director of University and Higher Education, Manipur, after the issuance of the Government order number so and so, now cancelled, the operation of all such orders are kept in abeyance until further order. A separate order is to be issued by the Director of University and Higher Education, Manipur, in this regard. From the part of the government, who is the issuing authority of that order dated 29 September 2021, by order dated September 2023, it has been cancelled, Lordship. This is the subject matter of the writ petition matter.
Correct.
Then next page, Lordship, page 21. Director also issues similar order, and the Lordship, this order has to be read with corrigendum dated 14 October 2023, which Lordship will find in the affidavit filed is the respondent filed on in October 2023, page number 48. Corrigendum.
1 second. Affidavit. been filed in the missed case.
No, Lordship, in the main. In the missed case, Lordship, neither the State Authority or appellant have not filed any return of 6 months. So whatever I stated in the MC, Lordship, MC 41, it's done uncontroverted manner. Lordship found a criticism dated 14 October 2023.
No, which affidavit is this? There's so many
It is affidavit filed by respondent number 1 and 2 in reply to the additional affidavit filed by the appellant.
To bring on record subsequent events.
Yes, 17 October, that affidavit. Page 48, Lordship. This page 48 has to be read with page number 21 in my MC case, my Lord, 3rd September.
Registration. Page?
Page 48.
1 second.
First may read the page 21 of MC, 3rd September 2023. Whereas it has been conveyed by Department of Higher and Technical Education, Government Manipur, ordered at the so.
1 second.
Lordship found it. In the MC case, page number 21, annex M7.
Now, this is filed by Thanomi Keshing.
Right. Yeah, right. Page number 48.
No, I'm just sure that we have the correct affidavit.
Yes, page
now,
number 48.
which page of this one was the affidavit?
Page 48. Original.
48.
Yeah. Because this order will be part of the order dated 3rd September 2023 at page number 21 of MC, M7.
Corrigendum.
Yeah.
Okay.
Lordship, first I take Lordship to page number 21, MC.
Yes, that we've seen.
It has been conveyed by Department of Higher and Technical Education, Government Manipur, so that the government ordered dated 29/9/2021, dissolving and concurrently withdrawing the suspension grant provided to so has been cancelled with immediate effect from 1/9/2023. After a minor and detailed consideration of the said government order dated 29/9/2021, and that the Honorable High Court of Meghalaya latest order dated 31/I/2023, whereby an opportunity has been afforded to the State of Manipur to take remedial measure as suggested by the Honorable High Court of Manipur. In December, and whereas Department of Higher and Technical Education, Government Manipur, by order dated 1st September 2023, has conveyed to issue an appropriate order in regard to the said government order dated so in view of the acceptance of the suggestion made by the Honorable High Court of Meghalaya. Now, therefore, the said earlier order dated 29/9/2021 is hereby cancelled, and with immediate effect, subject to the condition that State of Manipur reserves the and keeps open its legal right, contention, and remedies as are available to the State of Manipur under the Manipur Education Code 1992 and the other relevant laws as applicable to initiate fast processing by keeping the same issue open for further consideration. In regard to subsequent order issued by the so after the issuance now cancel the operation of all such order against until further order. Lordship, as seen from this order, another issue by the Director of Education on 18 December 2021, which was also a subject matter with writ petition. It is
come back to corrigendum, Mr. Pono. We don't
yes,
understand.
it is not there. That's why corrigendum. Now, therefore, please
para
read,
3, they say para 3 of this of the order date 3rd September.
Yeah, right.
Is corrected. Now it says now therefore. Yes. So
now therefore, this had earlier government order dated 29/9/2021, and the Directorate of University and Higher Education order dated 18 December 2021 are hereby cancelled with immediate effect. Subject to the condition that the State of Manipur reserves and keeps open its legal right, contention and remedies as are available to the State of Manipur under the Manipur Education Code, and that the relevant laws as applicable to.
Where's 1812 order? What is 1812 order?
18 December 2021.
Yeah.
What you will find in the memo appeal, page number 93.
What does it say?
It is a lordship. The earlier order issued on 29 September 2021. They are making an allegation that it is the Director of Education who is competent to issue the dissolution order, not the state government. And that this order was issued by the Director, Lordship, by dissolving the
1812.
Yes, with retrospective effect.
So corrigendum just to the effect that 1812 order goes also.
Goes, Lordship.
That's the only thing.
Yes, and the Lordship, meaning thereby two primary order, which is subject matter of the writ petition, now is no longer.
1812 is gone and 29 and 29.9 is gone.
Yes, gone. And this is the only two order, Lordship. On the basis whereof they are filing the case, Lordship, saying that it is contrary to the law. This is regarding the facts, my lord. Then, case number 22, and I say M8, 17 September 2023, Lordship. Lordship, it is altogether different proceeding, not connected with the proceeding before this court. In this proceeding taken up by the state government, what the government says, Lordship, earlier constitution of GB on 2nd March 2021.
Where are you reading?
No, I'm not reading, I'm only explaining,
Okay.
Lordship. Lordship, this is, as I submitted, it is altogether separate proceeding, not connected with the proceeding before
you mean
this honorable.
independent of what the early proceedings?
Right.
Because
And
you're reserving your rights to act in furtherance as per
not
rules
even
and orders.
to that, not even to that. What I say there, Lordship, when the DB was constituted on 2nd March 2021, Lordship, by one of the person who was acting as in-charge principal, when regular principal was suspended, Lordship, the person who was functioning as regular principal approached the court, challenging her suspension, and Lordship, the confirming charge of the in-charge principal to one individual called Sital Jit, Lordship.
Yes.
And the Lordship, that was challenged, and the court passed an order suspending the suspension order of the regular principal, my lord. In spite of the court's order, Lordship, that in-charge principal have taken step for constitution of the GB, Lordship, while it is to be done by the principal, Lordship. Meaning thereby, Lordship, a person who has no authority to act as a principal is the one who initiated the...
So this order wants to correct that, you mean?
Yeah.
Let's see what order says.
It says, merit. Whereas in terms of the government order dated 29/9/2021, the governing body of Chonoso was dissolved and concurrently the grant in aid to the said college was withdrawn and suspended with effect from Chonoso. Whereas the said government order has been challenged as in the court in relation to the same, a copy of the Chonoso passed by the Chonoso. And whereas a minor and detailed consideration of the government order number Chonoso had been done in regard to the opportunity being afforded to the state of Manipur to take remedial measure as suggested by the Honorable High Court of Meghalaya. It was deemed fit and proper to accept the suggestion and cancel the government order dated Chonoso inter alia by reserving and keeping open the legal rights, contention and remedy as available to the state of Manipur under the Manipur Education Code and other relevant law as applicable. This was to enable and empower the state of Manipur to initiate fresh proceeding by keeping the same issue open for further consideration with the leave of the Honorable Court Chonoso. Whereas government order dated 1st September 2023, the Governor of Manipur was pleased to cancel the government number Chonoso and convey the approval to the Directorate of University, the Higher Education to issue an appropriate order in that regard. Whereas Director of University and Higher Education Manipur was directed to issue a separate order that consequent upon the cancellation of the government order in Chonoso and all subsequent order issued by the Government Manipur and Director of University and Higher Education Manipur. After the issuance of the said government order, Chonoso was now cancelled and kept in abeyance until further order. Whereas Director of University Government Manipur, acting upon the government order, Chonoso was pleased to issue an order on Chonoso cancelling the earlier order Chonoso subject to the condition that State of Manipur reserved and kept open the legal right contention, the remedy as are available to the State of Manipur under the Manipur Education Code 82 and the relevant law as applicable to initiate fast processing by keeping the same issue open for further consideration. The operation of all order issued by the Director of University and Higher Education Government Manipur after the issuance of Chonoso now cancelled were kept in abeyance until further order in terms of the Chonoso. Whereas the High Court of Meghalaya was pleased to observe in the subsequent court's order dated Chonoso that the governing body which was dissolved in terms of the government order Chonoso having been now cancelled, stood restored. It was further observed by the Honorable High Court of Meghalaya that it will open to the State of Manipur to take further steps in respect to the relevant college in accordance with law, particularly in terms of provision of the grant-in-aid court operating in the State of Manipur. Whereas now, a legal notice has been served to the Department of Higher Education, so calling upon the government to act upon court's order that had passed in this head with April. Now, whereas State of Manipur have reserved its legal right, contention remedy as are available to the State of Manipur to initiate fresh proceedings by keeping the issue open for further consideration as the government order that is so by issue without considering the merit by cancelling the government order that is so had been done in acceptance of the opportunity being afforded to the State of Manipur to take remedial measure. As suggested by the Honorable Court of Meghalaya, whereas the Honorable High Court of Meghalaya had also clearly granted leave to the State of Manipur to take further steps in respect of the relevant college in accordance with law observed in paragraph 4 of the court's order dated so. Whereas at the backdrop of the events and circumstances mentioned above, a detailed examination of all relevant case record and material are minorly carried out to ascertain the legality or illegality involved in the constitution of the disputed government body on 2nd March 2021. Now, whereas after a careful and a minor re-examination of all material record, it is noticed that an order that was issued by the caretaker governing body of the college placing Dr. N.G.A. Kasnedevi, principal of the Northern Birhari College, Pundrapam under suspension with effect from 27/11/2020. Whereas by another order that it was observed that Dr. N.G.A. Kasnedevi, the former principal of the college, has been kept under suspension with effect from 27/11/2020. By order of even number and accordingly, Director of University Higher Education Government Manipur, on obtaining approval of the government dated 7 December 2020, convey approval to the caretaker governing body to appoint Sri Nimomam Sitolji Singh as an interim principal in charge of the college with effect from 8/12/2020 until further order in the same was issued in terms of this order dated 8/12/2020. Whereas this had joined duty as interim principal in charge of the college on 9 December 2020. Whereas said interim principal in charge of the college, namely immediately on joining duty, submitted a letter dated 11/12/2020 to the chairman caretaker governing body for giving approval to the constitution of new governing body. Whereas meanwhile, Dr. filed writ petition challenging the suspension order dated 27/11/2020 before the High Court of Manipur. Honorable High Court of Manipur passed an interim court's order dated The operative person is reproduced below. In the interim, the order dated 27/11/2020 issued by the chairman, caretaker governing body in Northern suspending petitioner shall remain suspended till the next day. Was represented by Whereas said interim order was extended from time to time till the said writ petition was closed on However, it apparent from the recorded said interim court's order dated subsisted and was operating in full force till 2nd March 2021 without the same being vacated, modified, or stay. Whereas in terms of the said interim court's order dated Dr. stood restored as it should be regular principal, not in charge principal of the college, as the status quo ante position of stood restored as on 27 November 2020. Before passing the order number apparently order number 8/12/2020 being a consequential order issued in respect of the said order dated 27/11/2020, the appointment of as interim principal in charge of the college stood automatically withdrawn and inoperative in law. Whereas it is noticed that despite the operation of the interim order, Shri requested the Director of University and Higher Education to give approval to the constitution of new governing body of the college enclosing a list of members of the said new governing body. In the said list, member name of Shri is found to be designated as ex officio member in terms of the Manipur Education Code. But the principal is always ex officio secretary. In view of his holding the post of interim principal in charge of the college, a similar letter has again been submitted by by resubmitting the same list of members of the newly constituted governing body of the college, all the time exercising power and authority as interim principal in charge of the college. And the whereas Director of the University, to the referring and conveying approval to the state government in the constitution of new governing body in serial number 9 of the list of member so and so is designated as ex officio member. Whereas so and so wrote a letter addressed to the director of the university and the higher technical that in persons of the approval of the director of university and higher education, so and so regarding the constitution of new governing body, the director was requested to convey approval to the holding of the first meeting of the newly constituted governing body of the college on 27 February 2021. The said letter was written by so and so while exercising the power and the authority of the principal in charge, returning officer, governing body, election officer. Thereafter, so and so continue exercising the power and authority as principal in charge of the college and presided over the so and so. Whereas in terms of the order dated so and so issued by the director of so and so, the governing body of the college was constituted for a period of 3 years. In the list of members, as serial number 10, it is found the principal in charge of the college in the designation as ex officio member. Whereas after a careful and detailed examination of the above case record, it is noticed that exercise of power and authority as interim principal in charge of the college by Sri N. Chitalji Singh in the manner as stated for the purpose and after passing of the High Court's Manipur interim order dated so and so, filed by Dr. Ekasini, is without any authority of law and without jurisdiction. Accordingly, order so and so issued by the director of so and so is null and void ab initio being an invalid order. Whereas this said order dated so and so is an order issued in non-compliance in the violation of the interim order dated so and so, the order and the action constituting the governing body on 2nd March 2021 is an invalid order, as the said order is also a result of the other invalid action undertaken by so and so. But it is well known that an invalid action or order can only generate an invalid order. Further, an order invalid since inception cannot attract principle of natural justice in making a declaration to that effect. And whereas nobody can be allowed to take unfair advantage by committing breach of an interim court order and escape the consequence thereof by pleading misunderstanding and thereafter retain the said advantage again in place of the honorable court's order. The plea of natural justice cannot be made applicable in such situation, as no one be allowed to retain any benefit arising out of wrong order issued in violation of judicial order. Now, therefore, the Governor of Manipur is pleased to declare the government convey letter dated so and so, and the consequent so and so are null and void ab initio, being an invalid order issued in violation of judicial order, and accordingly convey the approval of the state government of Manipur to the director of university and higher education to issue an appropriate order in this regard. Accordingly, director issue on 12 September. Next page. Therefore, Lords have seen that proceeding of declaring the GB as null and void, it is altogether a separate proceeding. It is not connected with the proceeding now pending before this honorable court. This order is not challenged, but it appears that my learned friend filed contempt, that this order is in a violation of the honorable court's order, Lordship. And in the contempt, Lordship has to ascertain whether there is an element of entertaining that contempt petition under the contempt law. I'm not touching on that, Lordship. Now it is very clear that, Lordship, the primary two order, 29 September 2021, the 18 December 2021, because under the two order, it is non-consequential, because that ad hoc, Lordship, the caretaker governing body is no longer functioning. It is gone. Then the Lordship, then other order, Lordship, the, yes, restoration of the grant in at Lordship, since it has been restored once the dissolution order was cancelled, Lordship. Two primary order, illegality whereof has to be adjudicated upon in this proceeding, Lordship, is gone. In such circumstances, what is there to decide by this honorable court? I am posing myself this issue, and that this similar issue have come up in different cases. Lordship, may I take only one case, Lordship?
Yes.
2004, volume 11, SSA, page 168. Shipping Corporation of India versus Machado Brother Mala.
Case number?
Page number 168. I'm supplying the Xerox copy, madam. It is a case where, Lordship, the contract was cancelled, Lordship. That was stayed in the judicial proceeding. Subsequently, during the substance of the stay order, my lord, another order was issued, similar in the line. That was challenged, Lordship. And the case was filed by the other party.
Which para is relevant one, Mr. Pond?
Lordship, relevant para, Lordship, may I directly take to para number 25 and the 31.
25?
Yes, 25 and 31. You. Come on. Yes. May I directly take Lordship to para number 25?
Yes.
Lordship, but before I read para number 25, may I, Lordship, start from para number...
One second, Mr. Pond.
Yeah.
Yes.
Lordship, may I start from para number 23? Before I take directly to para number 25 and 31.
23.
23. In this very same case, this court quoted with approval a judgment of the Supreme Court of United States in Peterson versus State of Alabama, wherein it was laid down thus. We have frequently held that in exercise of our appellate jurisdiction, we have power not only to correct error in the judgment under review, but to make such disposition of the case as justice require. And in determining what justice does require, the court is bound to consider any change, either in the fact or law, which has supervened since his judgment was entered. Lordship, I am just reading for the benefit of my learned friend, Lordship. Error number 24. Almost similar in view taken by this court in the case of Jam Bishas versus N.K. Bhattacharjee, wherein this court held the dispute raised in the case has lost its relevance due to passage of time and subsequent events which have taken place during the pendency of the litigation. In these circumstances, continuing this litigation will be like flogging a dead horse. Such litigation, irrespective of the result, will neither benefit the party in the litigation nor will serve the interests of the union. Thus, it is clear that by the subsequent event of the original proceeding has become infructuous, ex debito justice, it will be due to the court to take such action as necessary in the interest of justice, which includes disposing of the infructuous litigation. For the said purpose, it will be open to the party concerned to make an application under Section 151 CPC to bring to the notice of the court the facts and circumstances which have made the pending litigation infructuous. Of course, when such an application is made, the court will inquire into the alleged fact and circumstances to find out whether the pending litigation has in fact become infructuous or not. Then, Lordship, may I directly take to para number 31. And the Lordship, as I was submitting that, this is a case where contract was cancelled, that was challenged, and there was a stay operating. During the substance interim order, another order was issued, And the Lordship, because of the issuance of this another order, it was contended before the court that by the subsequent act it became infructuous. For the reason, Lordship, application was filed under 151 CPC for closure of the yes, Lordship. That was accepted by the court, my lord. In view of this, what they have stated in para number 25. For the reason stated above, we are of the opinion that continuation of a suit which has become infructuous by disappearance of the cause of action would amount to an abuse of the process of the court. The interests of justice require that such suit should be disposed of as having become infructuous. This application under 151 in this regard is maintainable. Because, Lordship, the argument addressed, application filed for closure of the appeal was not maintainable. Ultimately, court held, in the view which is stated in the entire judgment, it is maintainable, and the Lordship case was disposed of in infructuous manner. Then, Lordship, another case, Lordship, briefly, I'll take my lord to 1996, volume 6, my lord. 1996, volume 6, SCC, page 291. I take Lordship directly to para number 9, para number 6, Lordship, relevant portion. Of course, so what is stated in shipping cooperation, Lordship, it was also already held 1996. Lord. J.S. Parihar. What is this? Come on. Parihar.
Which paragraph is a short judgment?
Yeah, very short judgment.
It's just an extract.
Yeah, extract.
Only 3 pages.
Yes, Parihar. But you know, what is this? Please do not confuse. Do it slowly. But the Lordship, the fact remains what the court say. When the Lordship, the order on the basis whereof claiming the existence of cause of action for filing a case is no longer in existence because of a subsequent action, Lordship, then there is nothing to decide.
Are you saying subsequent action, subsequent events?
Yeah.
There are two things. Subsequent action or events?
Lordship, Lordship, I would say.
You can see why this order subsequent action
I would say,
has been taken on events that didn't happen subsequently.
No, Lordship, Lordship, subsequent event and the subsequent action. Lordship, I would say, Lordship, it may have the character of subsequent event in view of the proceeding pending before the court, because in the order, the material portion and the facts pertaining to the continuation, the challenge of the order in the writ petition has to be referred to, otherwise it cannot be a speaking order. And why I say that it is a action separate from the proceeding and the subsequent action is for a reason that the Lordship. Declaration of the order, 2nd March 2021 as the null and void, Lordship, it is entirely on a different ground, which is not taken in the whole proceeding before the court, Lordship. Lordship is fully well aware that any order passed by the court, be it interim or otherwise, Lordship, it has to be followed. No one can violate. Lordship, it is already held in many cases, Lordship. Ravi Naik case, long time back. Of course, that is from disqualification case. Lordship is well aware. Fully well aware, we discuss everything time and again in all the cases, what is Ravi Naik about. And not only Ravi Naik, Lordship, in 2010 in Manohar Lal case, Lordship, same thing. Any order passed by authority, Lordship, it infringes any kind of order, be it interim or otherwise. It is a nullity in the eyes of law. That order, 2nd March 2021, would be a nullity in the eyes of law.
You're saying to draw that subsequent,
right.
prior events.
Right. That is what I'm saying. Order may be issued subsequently, but the Lordship, as I said, the order, whatever the order, to the extent of illegality, it may have, Lordship, unless it is pointed out, it remains operating. It becomes a good order. Once it is pointed out, Lordship, law opens its eye. and the consequential action has to follow. That is exactly what is being done in the present case. That's why, Lordship, it was declared null and void, because the authority who was closing their eye to the judicial order opened their eye, and the law opened.
So you mean to say that you have to take shelter of the order of this court, remedial measure,
Lordship,
that to open the eyes of the authorities
this
to,
is my submission.
to
And the
correct
Lordship,
whatever
the wisdom of the Honorable Court, Lordship, I cannot impose. Lordship, I cannot impose on this court. On the wisdom of this court, I cannot impose. But the Lordship, the fact otherwise, in the legal person otherwise, this writ appeal is nothing remains to decide in the writ appeal, because the main two order is now in operation, is in existence as on today. What is there to decide, Lordship? Whether the illegality to the order dated 29 September 2021 and the illegality to the order dated 18 December 2021, that has to be interfered with by this Honorable Court. And how this Honorable Court can interfere when order is not in existence, my Lord?
Okay, let's hear Mr. Sahu.
This is my summons substance.
Thank you.
And the Lordship, another thing. In similar case, in which my learned friends of the party, I was also a party, Lordship, I challenge the Lordship, the appointment of one in-charge in-charge director of RIMS was challenged by one person, by Lord. That was disposed of by not giving a positive order, Lordship, but giving a liberty to the authority in the event they want to fill up the post by an interim measure. Let it be done by following the law applicable in the RIMS, Lordship. And the Lordship, that writ petition, with this observation, writ petition was dismissed. Against that, Lordship, writ appeal was filed. And the during the pendency of writ appeal, Lordship, another order has been issued, Lordship, appointing the writ petitioner in that case as director in charge, Lordship. And that came up before the division bench of the High Court of Manipur, Lordship. And I said that this order is a continuation of the earlier order. So this court needs to give a finding on the writ appeal. And what the court says, Lordship, in my affidavit in opposition filed on 21st September 2021, and I say M9. Page number 19, Annex M9. I was representing the appellant. My friend, Lordship, was the representing the private party, my Lord. It is a very short order. By judgment order that is so, learned judge of this court allowed so, and the set aside so, issued by the Under Secretary, Minister of Health and Family Welfare, Government of India, whereby additional charge of post of Director, Regional Institute of so. Lordship found it.
This is my copy, we don't have it.
I'm sorry, 21st April 2023 affidavit. It is on record now.
21st
April 2023. Affidavit in opposition filed by on behalf of respondent number 5.
21st April?
21st April.
Oh, yes, okay. Fine, we have respondent number 5.
Right.
Yes.
I take Lordship to page number 19. And I say M9.
Yes.
By judgment dated 19 December 2022, a learned judge of this court allowed writ petition number so and set aside the order dated so issued by the Under Secretary, Minister of Health and Family Welfare, Government of India, whereby additional charge of post of Director, Regional Institute of Medical Science, Imphal was entrusted to respondent number 5 to the writ petition. Learned judge observed, however, that passing of the said order would not preclude the official respondents from making fresh in-charge arrangement in respect of the vacant post of Director RIMS Imphal, strictly in terms of the provision of Rule 12.13 of the Rules and Regulations of RIMS Imphal, aggrieved thereby Resolution number 5 in the writ petition filed this appeal. Shri so. Interference by the learned judge, as is evident from the judgment so, was primarily on the ground that Rule so was not followed. This rule made it clear that in respect of unanticipated vacancy in the post of Director RIMS Imphal, the Administrative Ministry was empowered to make an additional charge arrangement subject to the condition that officer to whom such additional charge is assigned is the senior most officer in the next lower grade. Learned judge found that in terms of the tentative intersessionality list, Professor in RIMS obtaining as on so person number 5, the writ petition stood at serial number 4, while the petitioner figured at serial number 2 above him. It is on dispute even now that no final seniority list is available at the moment. Person number 1 herein was found as senior to the appellant in tentative seniority list. Further, the learned judge found that authority had not given considered the cases of the senior officer while placing respondent number 5 as in charge director. It was RIMS. It was on the basis that learned judge invalidated the order that passed in favor of the so and left it open to the authority to make interim in charge so. It appears that pursuant thereto, Deputy Secretary, Ministry of Health, issued an order dated 16/1/2023, which read as follows. In compliance of so, entrusting additional charge to the post of director so. The additional charge to the post of director Impal is hereby entrusted to or till regular appointment of director RIMS Impal or till further order, whichever is the earliest. This issue with this so. In the light of the aforesaid development during the pendency of the case, the issue that arises presently is to what is left in the appeal for adjudication on merit. We noted that learned judge did not issue any positive direction in favor of the petitioner in so to the effect that she should be entrusted with additional charge of the post of so and merely left to the authority concerned to do the needful strictly in accordance so. The government of India, in its wisdom, has now entrusted the additional charge to the post so would contend that it would be necessary to examine whether the cases of other senior persons were considered when decision was taken to entrust the additional charge to respondent number 1 herein. However, in our considered opinion, any grievance that the appellant may have with regard to the letter dated so would constitute a fresh cause of action, as decision embodied therein was taken by the authority independently in compliance with the direction of the learned judge, and that they should follow the relevant rule scrupulously. As to whether there was any error on the part of authority in doing so would not fall for consideration in the appeal, and they would necessarily have to be subjected to judicial review by way of independent proceeding instituted in accordance law, Lordship. And the Lordship, after this, the appellant filed a writ petition challenging the subsequent order. Writ petition was allowed, and the Lordship SLP was withdrawn. Appeal filed before the decision bench was also disposed of in practice, meaning thereby the subsequent case challenging the subsequent order, invalidity whereof Lordship stood confirmed.
Settled everything later on.
Everything, Lordship,
Right.
subsequently. But the need to file a case challenging, that is the requirement of procedural law matter.
Right.
Now, Lordship, whatever the case may be, before us, Lordship, two things is very clear. Two things, which cannot be disputed by any party to the proceeding. That is whether that order dated 29 September 2021 and the 18 December 2021, whether it is still in operation.
Yes.
And if it is in operation, Lordship, definitely this court has to exercise its power to decide illegality or illegality otherwise.
Very interesting point.
Very interesting.
Because we think anyway we will sign.
What
that.
I'm saying, the Lordship, when that two order is there for consideration adjudication, Lordship.
You understand, son of substance, you have said that the basis on which the entire proceedings is based on is gone. That is your submission.
Right. And the Lordship, I'm afraid to say so.
Yes.
This subsequent order, Lordship,
It's another
this
challenge.
court may not have jurisdiction.
Exactly.
Because Supreme Court entrusted the matter only to decide the legality of the order. Learned single judge dismissing the writ petition, upholding the order dated 29 September 2021 and the 18 December 2021. That gone, Lordship. That's why, Lordship, what is there to decide?
This is an offshoot of the proceedings that have been transferred here.
Yes. The offshoot, Lordship, offshoot, Lordship, procedural law demands that, Lordship.
Procedural law offshoot be taken up in another multiple jurisdiction then?
They have to challenge it, Lordship. Yes, multiple jurisdiction.
Multiple jurisdiction, I'm
saying. Because it is a subsequent order.
I'll point that.
It is a subsequent order, Lordship. That's why shipping cooperation and in 1996, Lordship, very clear. Lordship, if shipping cooperation, we read the whole judgment. Lordship will come to know that.
We noted their submissions.
Yes. Because, Lordship, it is also the cancellation of the contract that was stayed and another order was issued. It is connected. It is connected, but nonetheless, what the court says that being a subsequent event, Lordship, the earlier processing where the challenge of the earlier order, Lordship, does not exist, so it has to be closed. That's
Right.
all.
Yes, Mr. Sahu. How long will it take?
10
minutes.
I
5
will
minutes.
take much time, my lord.
Yes.
My lord, the order dated 12 September 2023, my learned brother has just said that it is a separate order.
Yes.
Separate order altogether, so therefore it requires to be challenged. Your Lordship, may I take your Lordship to page number 22? This document is in every document, my lord, every annexures, affidavits. But here, anyway, I take your Lordship to the affidavit, missed case filed by my friend, because it has been read from there only. Well, at page 22, the whole, right from para 1, my lord, right from para 1, it indicates that it is a continuation of the earlier orders, my lord. Right from para 1 of this order dated 12 September 23. Your Lordship, may I just take, my lord, whereas in terms of, my lord, right from 1 and particularly para 4, 5, 6, it clearly indicates that this order has been issued in continuation of the earlier order, 29th order, which they have cancelled themselves. So this is not a new cause of action, my lord. This is a continuation, offshoot, my lord, of the earlier one. And my lord, apart from this, even the order dated 18th, my lord, 18th also, your lordship may kindly see. 18th order, it clearly says, my lord, this order also, page number M10, clearly says that it is a order of earlier continuation order, whereas the Director of University Higher Education White order dated so and so, issued separate orders, order dated so and so. So these are all interrelated. It cannot be said to be independent, my lord, and therefore it can always, and that's the reason why this Honorable Court passed this order on that, my lord. This Honorable Court order dated 4th October 2023. 4th October 2023 order, my lord.
Yes.
My lord. This short order, my lord, I'll read out, my lord. In this appeal, which has been transferred to this court pursuant to an order of Supreme Court, the judgment and order impugned was passed on writ petition filed by appellants questioning the propriety of dissolution notice of September 29, 21, issued by the college with which the appellants are associated. When the appeal was taken up in right earnest for the first time on August 31, 23, a prima facie view was expressed that neither the impugned judgment nor the impugned dissolution notice of September 29 could be sustained in law, as the notice of dissolution appeared to be contrary to the provisions of the Grant in Aid Code. It was in such circumstances that the state of Manipur, which caused the notice of dissolution to be issued, was afforded an opportunity to take remedial measures at the behest of the state. The time for such purpose was granted till September 4. When the matter appeared on September 4, 23, the state indicated to the court that an order has been passed on September 1 by which the impugned government order of 29 so-and-so dissolution governing body of Naram Bihari College has been cancelled. In the order dated September 4, 23, the operative part of the order of cancellation was set out, and it was observed that the appropriate consequential order from the Director of University and Higher Education would follow. It was also recorded that as a consequence of the cancellation of the notice of dissolution, the governing body of the college stood restored. Your Lordship, I just want to emphasize one thing. This the order dated September 4, 23. This Honorable Court, my lord, expressed its happiness for taking the corrective measures.
October 4th, you mean?
Yeah, September 4th, my lord.
September 4th, October
Yes.
4th.
No, September 4th, my lord. September 4 was the order whereby the Honorable Court took note of their so-called corrective measures, and the so-called corrective measures, and expressed its happiness, saying that it is heartening. It is heartening to say that they have taken such a nice measures, my lord, which was in fact a fraud committed on the parties, us as well as the court, my lord. Then, my lord, it however transpired that despite cancelling the notice of dissolution, subsequent steps has been taken by the state. In effect, negated the impact of the order of cancellation of September 1, 23. The appellants complained that despite the order of cancellation, the governing body was not allowed to function in recognized. Then the state seeks time says that there is a good explanation to justify how the state acted after issuing the order of cancellation. Prima facie, it appears that the state may never have been interested in effectively annulling the illegal notice of dissolution of September 29, 2021 to restore the governing body of the college for such governing body to continue to run the educational institution. This would make the act of the state an act of contempt, as the state may have deceived the court into believing that the state of things have been brought about without such things being put in place. Accordingly, since the state seeks some time to explain its subsequent conduct, it is afforded a fortnight to file an affidavit in such an action. All action, my lord, this is very important, all action taken by the state subsequent to the order dated September 4, 2023, will abide by the result of the appeal and may be scrutinized in this appeal. So therefore, the order dated 12th, my lord, and 18th, these are both, this is open for scrutiny. This honorable court has already observed, my lord, this is subject to scrutiny by this honorable court, 12th September as well as 18th September. So, my lord, it has already been recorded by this honorable court, my lord, ordered that it will be subject to scrutiny and this will abide. Now, my lord, coming to the subsequent order dated 12th September, my lord, this 12th September is an order. They say that it was the dissolution itself was a mistake committed by them. The Constitution of the governing body itself, page number 13, my lord, of his misapplication.
It was done on the basis of the interim of that
my lord, but in that regard, my lord, may I take your lordship to their own letter, page number 55 of my additional affidavit, my lord, dated, this is a very important document, my lord, dated 29 September 23. Dated 29 September 23, my lord, my additional affidavit in the main appeal, my lord. My lord, this is very important, my lord. To the Director, University Higher Education, this has been written by, my lord, the Deputy Secretary, your lordship. Then, my lord, to the Director, University and Higher Education, humble request to constitute a new governing body for the term of 3 years thereof, Director, Manipur, letter number so-and-so. I am directed to refer to your letter number so-and-so, dated so-and-so, addressed to the Commissioner, Higher and Technical Education, Government of Manipur on the above subject, and to state that the Administrative Department has sought legal advice of the Learned Advocate General Manipur through the Law Department, which is reproduced herein as follows. My lord, this legal advice, my lord, my lord, by 12th September, my lord, they want to say that the governing body was constituted on the proposal of the principal, that is secretary, member secretary, which was illegal. The principal did not constitute the body. The principal only proposed it. And apart from that, the principal proposal was, themselves they have said that he was the principal. This letter which I am reading, my lord, page number 55 of my X13, my lord. My lord, this may only, kindly bear with me, my lord. This is a whole 2-page order, my lord. I'll read only. This is very important, my lord, because it speaks volumes, my lord. I am directed to refer to your letter number so-and-so, December 20, addressed to the Commissioner, Higher and Technical Education, Government of Manipur on the above subject, and to state that the Administrative Department has sought legal advice of the Learned Advocate General Manipur through the Law Department, which is reproduced as follows. The matter relates to the constitution of new governing body of Naram Birhari College, Kundrakpam. As per record, 3 years term of the previous governing body expired and the caretaker governing body was constituted on so-and-so for a period of 6 months, and the same was also extended. In the meantime, the Director, University and Higher Education, Government of Manipur, by letter dated so-and-so, submitted a proposal for constitution of a new governing body, Naram Birhari College, Kundrakpam, on the basis of a report dated so-and-so received from the principal in charge, Naram Birhari College. He says that he is no more principal, therefore his proposal was accepted by us, we have committed mistake, now we are rectifying it. That is what they are saying, because there is a court interim order, but by virtue of interim order, he is no more the principal. It is also on record that Sri Vikasni Devi, Principal, Naram Birhari College, was placed under suspension on 27/11/2020, and one Sitaljit Singh, HOD Physics Department, has been appointed as in charge principal by order number so-and-so. Later on, the Honorable High Court of Manipur, this is the my lord, issue raised before the Advocate General for his opinion. On the other hand, the appointment of N. Sitaljit Singh as principal in charge Narun Bihari College is not challenged, and as such, he is continuing to discharge his duties as in charge principal Narun Bihari College. In view of the factual position stated above, there is no irregularity in the process of constituting of a new governing body Narun Bihari College for a term of 3 years. AD may take necessary action. Administrative department may take necessary action for conveying approval to the constitution of a new governing body Narun Bihari College in terms of Rule 10 of the General Principles of Condition Governing Payment of so and so. As per record, it is found that N.G. Kasni Devi submitted her joining report by way of taking self-charge to Chairman so-and-so. On the other hand, Sri N. Sitaljit Singh is also holding the office of the Principal Narun Bihari College on charge basis by governing body's order dated so-and-so. This being the position, the notification for joining service of N.G. Kasni Devi be put up and processed to file the appropriate action be taken and issued necessary orders in this regard for placing an appropriate person to be the principal Narun Bihari College. Till the decision, that's very important, my lord, till the decision is taken by the competent authority, Sri N. Sitaljit Singh shall be deemed to have been discharging his duties as in charge principal Narun Bihari College, and the process for constitution of a new governing body in terms of the relevant rules may be complete. So, my lord, this is the principle, my lord, on whose proposal the governing body was constituted. They say it is illegal because by then interim order was there, so he should have not been the principal. It is they who, the person who are responsible for implementing the court's order, themselves are saying that we did not comply the court's order, so therefore his continuation is illegal. In that regard, my lord, I just want to bring, they are taking advantage of their own mistake, my lord. And also, my lord, these issues are all were not put up before the learned single judge, neither before the division bench till today, till only now after taking the so-called corrective measures, my lord. Now they are coming, which is not permissible by law, my lord. The issues which not been placed before the learned single judge cannot be raised at this moment, my lord. My lord, 2011 volume 6 SCC. 2011 volume 6 SSC 199, para 19 only. I'll not take much time, but I'll take very short. I'll go. Para 19. I'll go straight to para 19, my lord. These things, my lord, all these developments is pertains to 3 years back, my lord. It was there when the writ petition was being heard. It was there when the writ appeal was being heard. And the, my lord, one important thing is that the writ appeal at the time of admission, the learned single judge judgment was suspended, my lord. It was never implemented. There is another contempt petition pending at Imphal, my lord.
See, one thing, Mr. Sahu.
My lord, para 19, my lord.
Yes.
We are, page, my lord, 206. We are in complete agreement with the High Court that having failed to adduce any evidence before the tribunal which could enable it to invoke the prohibition contained in Section 79A of the 1961 Act, and having failed to raise this plea before the learned single judge, the appellants were not entitled to resurrect the same before the division bench. In any case, in the absence of any tangible evidence, the tribunal or that regional High Court could not have denied occupancy, so and so. And, my lord, regarding taking advantage of his own mistake, my lord, this has been held repeatedly in many cases, my lord. One cannot take advantage of his own. 2012, volume 9, SCC 310. It has been reiterated in till 2018. 2012, volume 9, SCC. Given the list. One cannot take advantage of his own mistake. 2012, volume 9, SCC 310. Is that there? My lord, we have got the photocopy, my lord. I take straight to the relevant portion, my lord. Para 28, my lord. Para 28. My lord, a person, page number 319, my lord. Page, my lord, shall I read, my lord?
Alleging his own
yes, my lord. And cannot be heard at any forum. What to talk of a writ court? As explained by the legal maxim, alleging Schwam, so, my lord, if a party has committed a wrong, he cannot be permitted to take the benefit of his own wrong.
So many judgments thereafter, my lord, has been cited in this case. And my lord, what they are saying, my lord, that they committed the mistake by not implementing the interim order of the learned single judge, and so therefore his proposal was illegal. And where is the learned advocate general himself, and the commissioner himself has said that he is still continuing, deemed to be continuing. And my lord, one more thing.
I think we have heard on the
one thing, my lord.
Yes.
Can I, my lord? My lord, those orders which were not before the court, before learned single judge or division bench, and which is illegal, can also be quashed, though not challenged, though not before the court, my lord. This has been held by the Honorable Supreme Court, my lord.
Yes, you kindly.
1997, Volume 1 SCC, page 621. 1997, Volume 1997, Volume 1 SCC, page 621. And this judgment has also been followed, my lord, in 2011, Volume 3 SCC, 436, page number para 62.
Which is the other case? 2003.
Other cases, 2011, Volume 3 SCC, 436, para 62. It has been followed therein. I have not given this citation I have given, but my lord, para 62. I have given this one also, no? Yes.
Right. This is para?
This one is para 9, my lord. Para 62, my lord. 2011, para
97?
97, para 9, my lord.
Para 9. Okay.
Your lordship may kindly see, this is a very elaborate, this is very nicely drafted. My lord, para 9, I read out, my lord, page number 625.
Yes.
625.
Yes.
My lord, the government thereby has tried to give seniority to the respondents and those order of ad hoc employees by treating them as permanently appointed promotees since 2 years after the date of their joining to the post of so-and-so. Thus, the respondents and other ad hoc employees who had been appointed temporarily and whose services were not regular and were regularized only on so-and-so will have to be treated as permanently appointed in 1974 as they were for the first time appointed in those posts. The said order was not challenged in the writ petition as it had not been come to the notice of the appellants. In the present case, it did not exist. It has been filed in this court along with the counter affidavit by respondent number 3789 is relied upon by all the respondents. This order also deserves to be quashed as it is not consistent with the statutory rules. It appears to have been passed by the government to oblige the respondents and similarly situated ad hoc employees, even if not challenged. Okay, there are various other judgments, I don't know. And
we will. The thing is that we are constrained for time.
Yes,
so
yes,
we will pass order on the mis case first, Mr. Pawnam.
I would like to only clarify only 2 minutes, my lord. My learned friend was taking to order dated the order of 2021.
In this case,
2021.
We are at very difficulty, because we have been coming for, this is the 9th time that
you can appear virtually, that hybrid mode.
Yes, my lord. And my lord, one thing, the term is expiring in February, my lord. Though this honorable court has already ordered that the entire period will be restored.
We'll keep a short date for the main matter. Don't think that this matter today.
Well, this week, let it be done this week, my lord. I'll stay back, my lord.
Suppose, see, we have not decided Mr. Pawnam's application.
Sorry, my lord.
We have to decide Mr. Pawnam's application as yet.
Yes,
that we'll have to consider.
Well,
so, we'll consider. And if suppose he succeeds, that means you're free, from all other encumbrances. And if you're not, then you have to come back this week or maybe next week. Yes.
Worship, my learned friend was referring to a letter dated 14 January 2021.
Yes.
I refer to that on the advice of the learned advocate general, lordship, that this gentleman, in spite of having a judicial order, is to continue as a principal in charge, lordship. Law is very clear, lordship, that is a promissory estoppel against law, number one. Number two, lordship, the audacity of this statement submission. Your judicial order is nothing when there is a executive order advice of the learned AG. Which one will prevail? I don't have to apply.
No, executive order, another explanation, my lord.
No, please do not interfere.
Page number 57, my lord.
I'm addressing the honourable court, my lord.
Yes, please.
I'm addressing the court, my lord, not my friend.
No, one thing, my lord.
I am not
just to cut short the time, my lord. Just cut short the time. I did not read this document. This is there, my lord. The government executive order also is there.
Yes, that is what I'm submitting, lordship. What about the government order or otherwise?
What Mr. Pawnam is saying, he's saying that, notwithstanding the existence of any executive orders, when an error is there, and if the court orders are there, so that means it is a bounden duty of the authorities when the eyes have been opened to make corrective measures as what has been done by remedial.
That is my submission.
That is the basis of the submission.
Yes. And on this submission, Lordship, what they say in this letter which my learned referred to, that Lordship, Learned Advocate General opinion will be prevail over the judicial order. Whether this kind of submission will be accepted by any court in this country, my lord, where constitution mandates, my lord. That is one thing I would like to point out. And another judgment which my learned referred to, that Lordship, that one cannot take advantage of his own mistake. Whether that will be applicable in the case when it relates to a judicial order and its implementation thereof, my lord. I don't have to make submission, Lordship, elaborate submission. But things are very clear that the MC 41 of 2023, filed by me, Lordship, it is not objected by filing an objection by any party to the proceeding, my lord. Only legal proposition my learned friend can submit, which he has done, which I say that, Lordship, promissory estoppel, Lordship, cannot play against the law. And the order passed by the court, High Court, is a law, under the law, under the Constitution.
But there can be no estoppel against law.
Yes.
I mean, yes.
The next, I read out one Advocate General's opinion. There's next another letter also.
The submission of Mr. Pawnam, he said, seeks to cover that, saying that whatever might be, notwithstanding the executive orders or any opinions, the thing is that, yes, Mr. Hari, I hope you don't have, you support submission of Mr. Pawnam, I suppose.
I will be supporting Mr. Pawnam's submission.
Yes.
I will be supporting Mr. Pawnam's submission.
I'm sorry.
The whole attack seems to be on the state, Lordship. That is the difficulty which I need to clarify on 1-2 points.
Lordship, my government may clarify. But Lordship, that's all my submission. And the last time, Lordship, I caused inconvenience to all my friends. For that, Lordship, I'm sorry, Lordship. And I'm grateful for accommodating me, man.
No, you are not, you are unwell. So on health grounds, there can be no estoppel, you can say. Yes.
Lordship,
we'll give you 10 minutes max.
Yes, I will not be long, Lordship. I will not. Lordship, when we look into the Miss case, Lordship, my learned senior counsel has already dwelt upon the facts and the situations which have arisen, resulting in passing of several orders by the government, Lordship. In the affidavit deposed before this court, as a way of explanation, and thereafter even in the contempt, we have made a categorical deposition on oath and affirmation that we had no intention, the government had no intention to pass any subsequent order during the pendency of the present case. That is what has been categorically stated repeatedly, Lordship. Because of the matter being opened up by this Honorable Court in the order of 31st August, because taking a prima facie view that your dissolution order violates the principle of natural justice of not giving pre-decisional hearing, but post-decisional hearing is there in the last para of the same order.
There you refer to last
and they resorted to the post-decisional hearing by filing a writ petition asking for disposal of their representation. The representation was disposed of by the state in a manner of giving full opportunity of hearing in a post-decisional hearing. No prejudice has been caused to them, neither has been alleged also, Lordship. There has to be some allegation that pre-decisional hearing you never gave, that's why post-decisional hearing has prejudiced us in this aspect. Nothing is given. The law is settled on that count, Lordship. Now going into the second aspect, Lordship, had it not been a case, Lordship, that this Honourable Court had not opened up, Lordship, the Honourable Court order clearly says we leave it open to the state to take a decision, Lordship. Now the issue which came up before the government was there, Lordship. It could have gone into the aspect of issuing a fresh so-called notice again, as suggested by the court in the open court that day, Lordship. My Honourable Justice was also there. But, Lordship, the fact remains is that, Lordship, when we peruse the file, there was an apparent case of violation of this interim order, which, despite knowing, the director knew it, Lordship. The director knew it, for which a letter is written. Mr. B.P. Saw has my learned senior counsel has read out this letter, but he has not read out the letter before to that. This is a letter of 31st December 2020, with all bona fide honesty and integrity. The director writes to the Commissioner Higher Education, the respondent number 1, kindly seek an opinion from the law department to ascertain who will be the principal in charge, because there is an order of the court. And there is another who is taking interim in charge as per the caretaker governing body. Lordship, is not a case that it was not in the notice of the government. But for some reason, Lordship, if you look into the next page, Mr. Saud, Learned Senior Counsel has referred to the last line, but has not laid emphasis on the line before that. It says, Lordship, it says here, on the other hand, series so-and-so is holding charge, Sitalji is holding charge, office of so-and-so on in charge basis by government order dated. This being the position, the application for joining service made by Ekasini to be put up and processed in the file and appropriate decision be taken. This Ekasini is the order passed by the court and issued necessary order in this regard for placing an appropriate person to be the principal. It doesn't say principal in charge. It uses the word principal. He can never be the principal. Because he's interim principal in charge and he's not the principal. Norim Bihari, in consonance with the order of the Honorable Court, means that the order itself says, the AG gives the opinion that you comply with the order of the Honorable Court immediately. Lordship, when did they comply? They purportedly said to have been complied, Lordship, on the day the governing body, previously in all other proceedings, it shows that Sitalji Singh ex officio member. In the impugned order, it shows principal in charge ex officio member. In the Lordship, in the rules, there is no provision which says you can show interim principal in charge as the ex officio member. It's already the principal who is shown. So, Lordship, there is apparent mistakes committed by the government, but the basic question comes up before this court is that despite the mistake being committed, the government could not cure it because the matter was already subjudiced before the court. Lordship.
So now, after you got the handle from the court,
Lordship, Lordship, I will just cite one. I will just cite one judgment, Lordship. Lordship, because it was kept open, Lordship, 1 2 judgment, Lordship. Now, it's a case, Lordship, of Director of Education, Uttaranchal. Para number 7, Lordship.
Mr. Rani, it's all right. And because actually today we're concerned only with Mr. Paunam's application. That's
but Lordship, what I wanted to say,
orders will pass.
Lordship, just I wanted to point out one legality.
If we find that
Lordship, what this says is that
submissions and the material are very compelling, then maybe the future course will be decided. That's the only thing.
Lordship, but the fact remains is there, Lordship, in all these judgments which is there, which I'll be citing the 4 judgment, 5, 6 judgment, Lordship, on the issue. Okay. Lordship, Lordship, the law is very settled, Lordship. It is no more res indigera. It is a clear-cut, settled case of law that when an order is kept open, when the Honorable Court passes an order keeping it open to the state, no specific directions are passed, Lordship. No specific direction in the sense that you have to do this. If we do not do this as directed, Lordship, we have something to say. We don't have anything to say, I want to say, that why we have not complied. But when it is kept open, this question of interpretation comes, Lordship. The interpretation of the government can be that which may not be digestible to any one of the parties, Lordship. In that event, Lordship, the contempt would not lie, first point. Then the subsequent course of action comes in, Lordship.
We have not run up contempt. We're going to examine the contempt.
My submission is that...
Are you already saying that...
not about contempt. Not about contempt. To that extent, I'm saying that a subsequent course of action arises, as per JS Parihar case, which my learned senior society, settled case, Lordship. He says that, Lordship, the subsequent course of action arises, the Honorable Court will not go into a judicial review of that issue.
Of course.
You will have to exercise, you have to go into a question of going into filing a fresh case for the fresh course of action which has arisen.
Take down.
I'm deeply obliged. I have one document. Lordship will kindly see. This is in another case also, my Lord. Same college. This is look after principal was allowed to.
Answer documents. Yes. Miss case number.
My Lord, can the main case be taken up within this week, my Lord?
We have not decided. Suppose due to compelling submissions and materials of Mr. Paunam, suppose he lands up victorious, then main case doesn't arise any further. But you see, so we'll not put the cart before the horse. We'll examine it. Yes.
Deeply obliged. We have deeply obliged.
41, right? Number 41. Yes. 1 second. Let me.
My Lord, before the order is my affidavit may kindly be taken on record.
Contempt?
Yes, Lordship.
No, that will come to Panki the miss case first.
Deeply
we'll take it one by one.
Please,
otherwise, there's so many connected matters we might. Yes, in this miss case number 41, 2023. This application under section 151 of the CPC bring for closing the instant writ appeal has been heard today. Stop. Is there one which has been passed by today? We'll check with the order.
This application under section 1.4 bringing for closing with the detective has been heard today.
Have been heard today, yes. Orders will follow.
My lord, we are only afraid, my lord, that whole January will be holiday and February is the last, my lord. Their term is expiring in February, my lord.
Yes, orders will follow. Yeah. Right, stop. And the next, in contempt, number 26, affidavits have been filed by both the respondents, here 1 and 2, and the same are taken on board. Haven't filed today. So in the main case, we'll keep an open date. List on so and so. Yes.
Can it be, my lord? Can it be this week?
Yes.
The main case will be listed on, my lord.
We'll sit in the main case.
No, I see.
Come on. The disposal.
Orders will follow. We'll try to pass it within. We'll not. So, tentatively, we listed on the 11th.
11th, my lord, let it be on 12th or 13th.
Okay, 12th, tentatively.
12, Lordship, 13 and the 14, Lordship, are not available.
13, 14, you're not available?
Yes.
You're not available on 13 and 14?
Meaning by value for 12, I have to come on 13. No? 13, 14, Lordship, I am not either in Shillong or in
12 is not, we have a holiday here.
We have a holiday there in Manipur, but I am in Delhi.
No, here also you have holiday on 12th.
12 holidays.
Let it be, Lordship, after 15.
No, then we'll decide there after 15. Also, we are pressed for time. Yes, we have other matters. Yes, we will pass it. You tell your juniors to contact the court master, right? I'll just talk to her after this one.
My lord, 15 in that case.
I don't know. No, Lordship, when my lord will dispose the MC case, we cannot impose on that.
I'm not imposing. My lord, I'm not sure. What kind of submission, my lord?
Okay, yes.
You're asking
Next matter.
for fixation of date of writ appel, which can be decided now.
My lord, your lordship proposed tentatively. That's why I submitted, and my friend is agitated for that.
Obligation. Diplo.
It's good. Healthy. It's very healthy. Yes. What is this?
Item number 5.
The time may not permit today.
What is this one? Who's
Mr. Nath is there.
Who's Mr. Nath?
My lord, I have received the affidavit filed by the petitioners. My lord, I may prep that matter may be disposed of relying on the page 8 of the affidavit, my lord. Page 8 of the affidavit, they have assured that he will be allowed to join in terms of the direction of the tribunal. So, it is a letter issued to the Assistant Solicitor General.
What affidavit?
Dated 18/11/2022.
I filed an affidavit on 1st of December, my lord.
What's December?
It's a small affidavit, my lord.
Okay.
Affidavit by the petitioners, my lord.
Lecture 4. Yeah, all right, lecture 4. Yes. Yes, what do you have to say about this?
My lord, what happened, my lord, earlier when the matter was heard, this honourable court expressed that the transfer of the petitioner, my lord, from Shillong to Tura may not be, there may be some element of malafide. My lord, that point of time, this fact was not placed on record, my lord. In fact, it was not in my knowledge also, that there is a departmental proceedings going on against the petitioner, my lord, for defalcation of money. He is working in a post office. What he did, my lord, when he was in charge of certain post office, he defalcated depositors' money, my lord.
So what is the purport of this order?
My lord, the purport
around Shillong. They have the
my lord, on my intervention, my lord, after the last hearing, my lord, before
so you want
the
the matter to be heard.
My lord, though in my intervention the department has agreed, my lord, but looking at the credential of the petitioner, my lord.
Whether you're considering posting this respondent in and around Shillong, or you're going to resist that also. What is your stand?
My lord, my stand, my lord, That is where little ambiguity is there, my lord. Because on my intervention, the department is written to me that.
What is your stand now? Is there a post available here?
Well, we'll have to look for some post, my lord. We'll do
then,
that.
Mr. Nath, we'll have it after 2 weeks.
My lord, some small prayer, my lord, small prayer before, small prayer before before vacation, because my lord, he is
before
not,
vacation,
they are
before
not aligned
vacation.
to
List this matter, we
my lord,
4th, list on 11 is a fixed matter for further consideration. Yes. And if he doesn't come up with any instructions, if
only my problem is that, my lord, only my problem is that I am not getting salary, and because I am not being allowed to join anywhere, my lord.
That's not correct, my lord.
Then we'll not go into that now.
That
we'll finish on 11th, yes.
My lord. 11, my lord.
11th.
On 11, my lord.
Yes, yes.
On 11. Oblige, my lord. On 11. Oblige.
On 11th.
Item number 3.
Oblige. Deeply oblige.
May it please, Your Lordship.
Yes, Mr. Yes.
This, Your Lordship, this is issue relating to imposition of cess on mineral by state government, my lord. It is awaiting the outcome of the matter which is referred to 9 judges bench. Your Lordship may peruse 30th March 2021 order, Your Lordship.
It's still
March
pending or it's over?
It's still pending. It's still pending, but it may come.
Parties submit that the matter, the incident, the matter, the legal issue, the legal issue which is in question in these petitions. The issue in state petitions is still pending before the before 9-judge bench of the Supreme Court. List after 6 weeks. Parties at liberty to mention if there's any outcome before the next date. Single bench at 2 o'clock.
2 o'clock. Possible.
To give you time for lunch.